Recording in progress.
मैम 11:30 हो गया माइक सभी अपने म्यूट रखिए। जब क्वेश्चन आंसर सेशन होगा तभी आप माइक अनम्यूट करें। साक्षी मैम ओके।
Yes, sir. A very warm good morning and welcome to all of you. I am Sumit Sharma, student of BLLB, third year faculty of law, Dr. A. N. Modi University. I got the opportunity to elaborate on this webinar and such dignity. First of all, let me tell you rules and regulations of the webinar. To keep the quality of sound functional, please make sure yourself mute. If you have any question during the presentation, please type them into the chat box. We will bring them up to our chief guest. I would request one more that you should maintain the decorum as much as you can. Okay, today on the auspicious day, I would like to tell all of you that Sambhavi ma'am, who is our chief guest of this webinar. Yes, ma'am.
continue.
Okay, thank you, ma'am. Okay, today on the auspicious day, I would like to tell all of you that Sambhavi ma'am, who is our chief guest of this webinar, she will shed light on the topic stages of criminal trial process and career aspect. She is a judicial magistrate at Ghazipur, Uttar Pradesh. She has completed her BA LLB from HNLU, Chhattisgarh through GLED. She had attended several moot courts and parliamentary debate. She has also done internship under Justice S.K. Kathir, Judge Patna High Court, currently working in the capacity of Judicial Magistrate, Ghazipur, Uttar Pradesh, and is also worked as a law researcher in Supreme Court of India. It's a matter of great pride for us that we have our chairperson,
Manju, Manju lagi, Manju.
Maximum programs to the students for their bodies in the country like Bar Council of India, Judicial Council of India, NCAE, and many more. We offer various scholarships to the students those are coming from the rural background or they are coming from the poor families. We give them the financial assistance also. We have a very rich facilities in the university, like ATMs, camera vigilance, the rich library, and the gymnasium, the auditorium, the sports ground. So a lot of facilities available for the students as well as the hostel facilities also available. We have different kinds of sports curriculum as well as the help for the students. We have the mental mental system. We have the various clubs for the students who are giving them the opportunity to enhance their development, increase their personality. Once again, I'm not taking so much time. Once again, I thank you to all of you who listen me patiently. Hope this interactive session helps you all to take the decision to set your rules. Now, me and my students and the faculty members will be eager to listen. This is Untitled. Thank you so much.
Thank you, sir. Thank you, sir, for your valuable and precious knowledge. After that, I request to HOD ma'am, Dr. Santosh Sharma, to take forward the session with welcomes our chief guest. Now, please, ma'am, over to you, sir.
Good morning, everyone. I am Dr. Santosh Sharma, Faculty of Law. I would like to thank our chairperson, sir, Professor Dr. Devendra Bhuti, sir, for his presence in today's webinar, despite his busy schedule. And so grateful to him for allowing us. I also want to thank your registrar, sir, Mr. Sandeep Gupta, sir, for his instrumental support to us. Now, this is the time to show our heartiest thanks to our guest speaker, Mrs. Sambhavi Prakash, Judicial Magistrate, Gazipur, UP. Ma'am, we are so thankful to you for accepting our invitation and for your winning presence in this event. Now, I would like to call Sumit Sharma for further processing. Thank you.
Yes, ma'am. Thank you, ma'am.
Okay.
Thank you for your blessings, words. Enhance our morale. Now, I would like to invite Mrs. Sambhavi ma'am to continue this session with your precious and valuable knowledge. Over to you, Sambhavi ma'am. Please, ma'am.
Thank you so much. Thank you so much. Am I audible enough to all?
Yes, ma'am.
Okay, thank you. First of all, I would like to thank again Moody Institute for giving me this opportunity, this platform to interact. And thank you, Registrar Sir, HOD Ma'am, for such a warm welcome. And let's begin with the topic. Today's topic is stages of criminal trial process and career aspect. So first we will deal with the stages of criminal trial process. Okay. Now, I really want to take the topic. The topic is stages of criminal trial process, but I would like to take the topic stages of criminal proceeding because trial comes at a later stage. The idea is what I was thinking while selecting the topic is to give actually a brief idea or the structure as to how a criminal court functions, what is actually all the proceeding right from the stage of investigation till the trial. So the idea is to give a basic structure or the basic matrix of the functioning of the criminal proceeding. So if that's okay, I will begin with the right from the institution of the right from the offense stage. So if that's okay, do you all? So will it be an interactive session? Someone can
please, whatever you want to. Yeah, please.
That will be more helpful because I'm changing the topic a little bit, so I really wanted to know the concern of the students. Okay, so I'm talking about the stages of criminal proceeding, right? And then we will go to the trial process. So to begin with these stages, I hope everyone is having the Bare Act because in that case it will be easy to follow the lecture. Okay, so CRPC, if everyone is having, it will be handy. For the initiation of criminal proceeding, what is required is an offense, right? there has to be an offense. So what is an offense? We can see the definition of offense under section 2(9) in the definition clause. Any act or omission which is prescribed, which is as per the law of the land considered to be wrong. So that will be considered to be an offense. And the offense can be of two types, right? It can be a cognizable offense, it can be non-cognizable offense. So again, the definition of cognizable offense and non-cognizable offense is given under section 2C and section 2L. Since we do not have a, it's like the topic which I am thinking of covering will be very vast, so it will be beneficial if the students will pick at least all the section or take the note of the sections mentioned. So later on, if you want to revise it all, it will be convenient. Okay. I will appreciate really if there will be some reply from the students. If anyone will reply. No? Okay. So I'm assuming
whatever you take the as topic, which is very much useful for the students as well as our faculty and me also. So you just carry on. Whatever you want to take to us, you just give us, please.
Okay, yeah. Sure. So let's begin. So say suppose there is an offense, okay? An offense has been committed in the society. So offense will be either a cognizable offense or it will be a non-cognizable offense. Now say suppose a cognizable offense has been committed. Now what is the difference between a cognizable and non-cognizable offense? You can go through the definition, section 2C and section 2L. The cognizable offense is that offense where an arrest can be done by a police officer without warrant. And in the non-cognizable offense, no arrest can be done without warrant. Now to know which all offense falls under which category, the first schedule of the CRPC, column number 4, will prescribe as to which offences are cognizable and which offences are non-cognizable. Now the main difference is that here in the cognizable case, arrest can be done without warrant, and non-cognizable case, no arrest without warrant. Then again, in the cognizable case, there will be FIR. In non-cognizable case, there will be NCR, non-cognizable report. In the case of cognizable offences, FIR will be registered. Okay. And the third important difference will be that in the cognizable case, police will conduct an investigation by itself. But in the non-cognizable case, no investigation can be done by the police officer without the permission of the magistrate. That is section 155 clause 2. You can go through section 154, which is talking about the FIR, and section 155, which is talking about the NCR cases. Okay. Then, now say suppose it's a non-cognizable case, and even if it's a non-cognizable case, the police has conducted an investigation. So in that case, the investigation will be considered to be illegal, and the magistrate may refuse to take the cognizance of the case. Okay. Now say suppose the offense that has been committed in the society is a cognizable offense. So what will happen will that the informant will go to the police station. The informant he will report FIR. There will be filing of the FIR. Once the FIR has been filed, now the investigation stage begins and the police will conduct the investigation. That is, there will be collection of the evidence system, then collection any important document under section 161, then under section 164, statement of the informant, statement of the accused may be taken down. Under section 167, very important, is the remand proceeding. Say suppose the accused person is arrested by the police. So in that case, the police can keep it with himself maximum for a period of 24 hours. After that, he has to be produced before a magistrate. Once an accused is produced, then the magistrate can either send him to a police custody remand or for a judicial custody. Now, this police custody remand maximum can be for a period of 15 days. And the judicial custody, inclusive of those 15 days, can be maximum for a period of 60 days or for a period of 90 days, depending upon the nature of the offense that he has committed. Okay, the provision is section 167, very important. Now say suppose 60 days, say suppose maximum remand that we provide at one stretch of time is for a period of 15 days. When a police brings someone, the maximum time period is 15 days at one point of time. And then again, they keep on increasing till a period of 60 days or till a period of 90 days. Now say suppose 60 days or 90 days expired and the police has not submitted the charge sheet. So in that case, the accused will get the right of default. That is, the accused will be released from the custody. Now this will happen only in the case where the accused is in custody. This provision will not be applicable where the bail has been granted to the accused. Now say suppose the investigation is completed and the police has submitted charge sheet under section 173. So the charge sheet or the police report or the final report is submitted under section 173. Now say suppose the charge sheet has been submitted. So in the charge sheet, it will be written that the case is being made out or the case has been made out and these accused should be summoned by the court or is required to be summoned by the court. So now it is up to the court where that it may summon the accused. But here, then there can be again another thing that instead of filing of the charge sheet, there is a closer report filed. That is, the police is stating that in his view, no offence is being made out. So what will happen in this case is that no offence is being made out and no accused is required to be summoned by the court. Now these statements which is there in the charge sheet or it is there in the closer report, these statements are only the opinion of the investigating officer. The court is not bound by it. So here at this stage, the presiding officer, that is the magistrate, will be required to inform the first informant that the police has concluded the investigation and submitted a closer report. So, in this case, if the person is interested, the informant is interested, he may protest that closer report. So, there is a provision for the protest petition. A protest petition can be filed. Now, say suppose there is a closer report and a protest petition has been filed. Now, what all options are open for a magistrate at this stage? What kind of order a magistrate can file? So here in this stage, a magistrate can either accept the closer report or may ask the police to again make the investigation, or it may order none of these and it may directly summon the accused. Now this thing has happened in Nupur Talwar case, Dr. Nupur Talwar. Here in that case, the parents of Arushi, they wanted re-investigation to be done. The CBI has filed the closer report. The court here they neither accepted the closer report nor did they went for re-investigation. Rather, they summoned the parents of Arushi as the accused before the court, considering that there are material enough for considering that there is material enough against them. So this is again, here if the court summon, so again we are here at the stage of summoning. So when there is a charge sheet, after the charge sheet, there will be the summoning of the accused. That will be done under section 204 of CRPC. Okay, so this is section 204. Now, this is now say suppose the case is before the court. Now this is the first time since the inception of the offence, other than the copy of the FIR that is sent to the court. This is the first time after the offence that a document is presented before the court, and now the court has to apply its mind. That is, after the submission of the charge sheet, it is the court which is required to consider whether they want to take further steps or not. That is, to think about the taking of the cognizance of the offence. So cognizance of the offence is the most important work which as a magistrate, the first most important work which as a magistrate we are required to do. that is once a charge sheet is before us, whether we are going to take the cognizance or not. So what is the cognizance? Cognizance is basically application of the judicial mind only to the extent that after looking at the facts before us, whether we think that the material is enough where we should take further proceeding or further proceeding is required in this particular case. That is the cognizance. Now the stage of application of judicial mind will be different when we are framing the charges and is different when we are taking the cognizance. Okay. So once, because right now we only have a charge sheet, so we have taken the cognizance. So which section empowers us to take the cognizance? Section 190, very important section. So it is section 190, and if we go through section 190, so it says that Chief Judicial Magistrate or any other magistrate is empowered to take the cognizance. Okay. 190 clause 1 subclause A says, upon receiving a complaint, 190 clause 1 subclause B says, upon a police report, and 190 clause 1 subclause C says, upon information received. So is there anyone who can explain what these are? When I'm talking about an FIR has been registered, and then police has made the investigation and has filed a charge sheet. So under which section the court will take the cognizance in this matter? Will it be section 191A, or will it be 191B, or will it be 191C? So it will be section 190 clause 1 subclause B. That is upon the police report. Okay. So this is upon police report where till the stage here we are taking the cognizance. Now what about section 190 clause 1 subclause A, and what about section 190 clause 1 subclause C? So 190 clause, yeah, is anyone saying anything? So section 190 clause 1 subclause A is talking about the taking of the cognizance upon a complaint. So what kind of complaint here we are talking about? Now, if you go through section 2D, you may see the definition of complaint, and here we are talking about a private complaint which is made by a party. So section 2D, if I may read it, it's talking about complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offence but does not include a police report. So it does not include a police report. It's basically a private complaint which is directly made before a magistrate. Now the difference here is that when an offence is committed, and say suppose again a cognizable or a non-cognizable, some offence has been committed, and the person appears before the court and files a complaint. So here it is the complainant who will be required to prove the case itself. Here, since the police is not making any investigation, there will be no investigation by the police. The case will not be proved by the police. Rather, the case has to be proved by that private person himself, by the complainant himself. So this is the basic difference. So this is again one of the ways in which you can approach for justice. One is through FIR or NCR. The another is that is after the submission of police report, that is the charge sheet. And the second one is the complaint procedure. Okay. So say suppose a complaint has been filed, then again in the complaint all the facts and circumstances will be stated, then there will be the documents presented, the list of the witnesses will be presented by the complainant. Then after the application of judicial mind, the court may take the cognizance of the case. Once the cognizance has been taken, then here it is the responsibility of the complainant to prove his case. Thus, under section 200, the complainant and the witnesses of the complainant will be produced before the court, and he will give the statement on oath. So on oath statement will be taken by the court, and after considering all the statement, if the court feels that there is a case being made out, the court will again summon the accused under section 204, and if the court feels that no case is being made out, then there is a provision for the dismissal. Okay, so here again we come to the stage of section 204. So here, section 204 in the complaint case, we will be summoning the accused. In the case where the charge sheet is filed, we will be summoning the accused under section 204. Then we come to section 207, which is very relevant section, because since the inception of the case, this is the first time the accused is there, the accused has appeared before the court, and this is the first time where the right of the accused accrue to have all the documents, to have the copy of the charge sheet and each and every statement and every document which the prosecutor is going to rely upon, they can claim the copies. So this is the statutory right. This is the first time the accused is having any right in the criminal case. So section 207 has to be complied with. Okay. So apart from section 207, then if we move forward, we come to section 209, where there is a provision for the committal. Now it is very important to understand as to what is the jurisdiction of a magistrate. Now the jurisdiction of the police officer or the investigating officer has been made coterminous with that of the jurisdiction of the area magistrate. So even if the case is triable exclusively by the court of session, say suppose an offence of section 302, say suppose a murder has been committed. So it's an offence under section 302 exclusively triable by the court of session. But even in that case, the charge sheet will be filed before a judicial magistrate. All the essential steps which are before the trial will be conducted by the judicial magistrate, and then under section 209, the committal of the case will be done before the court of session. Okay, so this so in all these cases the committal will be done, and otherwise the other cases which is triable by the judicial magistrate will be tried by that particular court itself. Okay, so how do you categorize as to which offences are triable by the court of session and which offences are triable by the judicial magistrate? Judicial magistrate court is again you can look into first schedule, again it's given, and this first schedule is with respect to the IPC offences, and the second schedule is with respect to any other offences. Okay, any other offences under any other act. So here so that is the second schedule. More or less the provisions are similar. So now one more thing which I wanted to talk about is section 156 clause 3. The one way is through the charge sheet. The one way, when an offence is committed, you can bring it before the court through a complaint. Now say suppose there has been a complaint, and in the complaint the complainant says that it is not possible for me to bring all the evidences which is required. It is not possible for me to alone myself prove the particular case. Say suppose certain recovery is required to be done, or say suppose the accused is unidentified, or there is a very big scam which I alone cannot do. Then in this case, what can happen? In this case, once under section 156 clause 3, an application will be made. Now here the magistrate has the power that after going through all the facts and circumstances of the case, here the magistrate can either order for the investigation or can order for the case to be treated as a complaint case, but can also order for registration of FIR and for the conduct of investigation. So when under section 156 clause 3, the magistrate orders for an investigation, then the entire process of investigation, that is right from the filing of the FIR till the filing of the charge sheet, will be done. And here again, the taking of the cognizance will not be at the stage of section 156 clause 3. Rather, the taking of the cognizance will be under section 190 clause 1 subclause 3. So these are the ways in which a case can be instituted. And then now say suppose there is a case of murder, and then the case of murder has been committed to the court of session. So what happens after that? Now in the court of session, the prosecutor will open the case. Okay. the proceeding of the court of session trial proceeding, as mentioned under section 225 to 237. Okay, so here the prosecutor will open the case. Then, after explaining the case, he will be like arguing upon the charge. Now, say suppose he will be arguing on the charge, and then there will be the stage of framing of the charge. If the court feels that the case is not enough for the purpose of framing of the charge, then it is at this particular stage that the discharge of the accused will be done. So the discharge stage will always be before the charge has been framed. Once the charge has been framed, the court cannot discharge. The court will then only have the power to acquit. Okay. So before the framing of the charge, there will be the discharge. Now, say suppose the court does not discharge the accused, then it will proceed with the framing of the charge. Once the charge has been framed, now the court will ask the accused if he pleads guilty. If he does, then he will be convicted then and there. However, if he does not plead guilty, then in that case, the accused will be the prosecution will produce the evidence. Now, this is the particular stage where all the examination in chief, cross-examination and re-examination is conducted. Okay. So, the prosecution has produced all the evidences that it has got. Then will come the stage of section 313. Now, this is again of a great importance. Section 313. This is the first time when an accused gets an opportunity to explain to the court the circumstances that has appeared against him. So here at this stage, the accused will be asked in a question or answer form as like, you have been accused of committing murder of such and such person on this date, at this time and this place. Do you approve of it? So it's a question answer form. And here the accused may bring out certain defense. He may say that I was not present at that point of time at that place. I was in some other city. So he may take the plea of alibi there. Or he may answer anything. Now, what is the importance of section 313 statement is that it's not on oath. Okay, it's not on oath. It's not incriminating in nature. That is, if the accused say, I was not present there, rather I was at some other place, I was stealing some commodity from this particular shop. So even if he makes such a statement, this statement cannot itself initiate a criminal proceeding against him because it's a non-incriminating statement. So basically this section, the purpose of section 330, he can say anything out of the world, anything. But that thing is not binding on him. He is not on oath. But the only reason why section 313 is there is so that he can put up before the court. It's applying the principle of natural justice. That is, he must be heard. So a question is asked to him so that he can answer and he can explain to the court as to what has actually happened to him. So that is section 330. And once section 313 has been complied with, the last question in 313 is always as to whether you want to lead certain defenses. Defense evidence, whether you will be interested in producing the defense evidence. So if he is interested, the defense evidence will be produced by him. And after the evidences has been produced, again the chief cross and re-examination, and once the evidence is taken at this stage, then there will be the final argument. And after the final argument, there will be the hearing. So this is the procedure of the court of session. When we are talking about the magistrate trial procedure, now there is those cases which are tried by the magistrate. Now the trial proceeding, there are different trial proceedings which has been described under CRPC. So we can see that there is a separate trial proceeding for a summon case. There is a separate trial proceeding for a warrant case. And then again in the warrant case, there are separate trial proceedings for those cases which is instituted on a police report, and there is a separate trial proceeding for the cases which is instituted otherwise than on a police report, that is upon a complaint. And then there is a summon trial and there is a summary trial. So in the magistrate case, there are lots of trials, which is so it is again to be understood. The matrix is like it's it's a warrant case and a summon case. So how do you understand as to which particular trial will be conducted in which particular case? Then it is always upon the quantum of the punishment for which the accused has been charged. So say suppose if it is for more than 2 years, it will be a warrant trial. If it will be 2 years or less, it will be a summer trial. So summary trial is when when the offence is of 6 months or only with fine, then it will be a summary trial. So this is how it has been done. Now again, when we look at the trial of warrant trial, okay, the warrant trial upon a police report. So it is from section 238 to section 250. So upon a police report, so obviously when the requirement of section 207 has been complied with, the court will first of all look into as to whether the requirement of 207 has been complied with. If it has been complied with, then it will go on to framing of the charge. And if it feels that the charge is not required to be framed, then it may discharge. Again, if it feels that the charge is required to be framed, then after the framing of the charge, it will ask whether he pleads guilty or not. If he doesn't plead guilty, then will proceed further. There will be then again there will be the production of the evidences by the prosecution side. Again, examination, chief examination, cross-examination, re-examination, and again the state of section 330, then defense evidence hearing, then again the argument, and then the judgment. So it's pretty much similar as to that of the court of session trial. However, if we come to the complaint case, we see it is the warrant case, warrant trial, where the case is instituted otherwise than on a police report. So when it is otherwise than on a police report, it will be a complaint case. Okay. So in the complaint case, since it's a complaint case, there is a complainant alone. He is not proving the case. The case has not been investigated by the police. So here, first of all, evidence will be produced by the prosecution, by the complainant. Once he produces the evidences, then after considering the evidence, the court will think of framing the charge or not framing the charge. If charge is not framed, discharge. If the charges are framed, then again the same sequence will follow. The evidences will be produced. After the evidences are produced, then again section 313 will be there. After that, the defense will produce the evidence, and after that there will be argument, and then there will be the judgment. So that will be warrant trial. And then the summon case. In the summon case, again here, like we use the summon case, lots of all the summon trial which we face is basically the Negotiable Instrument Act. Now in the Negotiable Instrument Act, the requirement is that since we know for particular that there has been like the trial has to be completed within a specific period of time. So instead of framing of the charges, we just state the facts to the accused that you are charged with this for commission of this particular offence on this date. Do you plead guilty? So if he says he pleads guilty, then he will be convicted. If he says he does not plead guilty, then again there will be the framing of the charges. There will be no framing of the charges. Then if he says he does not plead guilty, then the evidences will be produced. And after the production of the evidences, again the same procedure, the evidence will be produced. 313 statement, one can skip 313 statement when it's a summoned trial. And then there will be defense evidence if any, there will be argument, and then there will be hearing. In the similar manner, we have the summary trial. The summary trial is nothing special. There is a list mentioned with respect to which these trials are to be conducted, and the time period is specified. The quantum of punishment is specified in that particular case. It's for the small little offences. The summary trial is done. Apart from this, now one important thing which I wanted to bring up is to understand from which stage to which stage it is investigation, then from which stage to which stage it is inquiry, and then from which stage to which stage it is a trial process. Now, from the stage of filing of the FIR till the stage of submission of the charge sheet, the proceeding will be considered to be an investigation. And from the stage of taking of the cognizance of an offence till the stage of framing of the charge, it will be considered to be an inquiry. And from the stage of framing of the charge till the stage of final judgment, till the time the judgment has been pronounced, it will be a stage of trial. Now, such separation has been done by the Supreme Court. There is no such separation specified in the CRPC, but it is through the lots of the judgment that has been pronounced in the due course of time that we find these things incorporated into CRPC. So, it is in the case of Hardeep Singh versus State of Punjab. It is a 2014 Supreme Court judgment. Here, the Supreme Court has stated that in case the trial is before the session court, the trial is said to be commenced when the charges are framed under section 228 of CRPC. In case the trial is of a warrant case instituted upon a police report, the trial is said to be commenced when the charges are framed under section 240 CRPC. In case where the warrant case is instituted otherwise than on a police report, the trial is said to be commenced when the charges are framed under section 246 CRPC. And in summon case, the trial is said to commence when the accused is asked under section 251 whether he pleads guilty or has a defense to make, since in summon case we do not frame the charges. So yeah, this is the framing of the charges till the judgment, and there are like under section 154 there is a compulsion on the police officer to report the FIR. Now this has been made compulsory in the case of Lalita Kumar versus State of UP, which is our 2014 Supreme Court judgment. So this is pretty much which I wanted to convey, because since it's right from the stage of investigation till the stage of trial. So rather than burdening you all with lots of information, I just wanted to sketch or draw the picture as to how from the inception of the case till the judgment, what all steps or what all procedure we do. So if there is any kind of question you want to ask, you're most welcome for it.
Yes, ma'am. Thank you, ma'am, for your valuable insights on the today's topic. Along with this, many participants got to learn a lot, and many questions must be comes in their mind. So now let's start the question answer round. For that, I hand over the topic. Topic, please proceed.
Good afternoon to all of you. This is Tawqir Hussain Khan, student of BLLB, Faculty of Law, Dr. K.N. Modi University. So it seems like people are so eager to ask some questions. So with the permission of our chief guest, I am moving on to the first question. That is, what can a police officer taking a confession of accused and further confession would be relevant or not?
Confession. Yeah, if I get the question right, we're talking about the taking of a confession by a police officer. So any kind of statement which is made before a police officer is not read by the court. The court does not go through it. The court does not consider it to be an evidence. Section 161, if you go through all these provisions, 162, and where to take the statement? If the accused wants to confess, then it is under section 164 mostly. He is brought before a magistrate. The magistrate takes down the confession, and then only it will be considered to be an evidence, means it will be considered to be readable by the court. So any statement given to the police. Now there is a very important, it's a rule of prudence as well, not only rule of law. So what's the reason? The police will, if say someone is in police custody, what happens in a police custody? You cannot even imagine. So if someone is in a police custody and then later on police says that that person has confessed before me and has written a statement, and if that person then, the accused then is appearing before the court and he's saying that no, I did not confess, rather the confession was forcefully made from me. So the court here, as a rule of prudence, has made this that no statement which is made to the police officer, all the statement which is made to the police officer will be used for the purpose of investigation. But then this is the reason why why examination, cross-examination, re-examination is done in the court. So none of the statement which is made to the police officer is read by the court. But rather a statement, if he wants to confess, he can confess before a court. If he wants to confess, he can confess before magistrate under section 164. Right?
Thank you for such valuable answer, ma'am. So I'm moving on to the second question. Where can a lawyer make his complaint? Police station or bar association?
A complaint by a lawyer, but a complaint of which nature? With regard to what kind of offense? He has all the options open. Means like if he wants to complain about anything in the bar, then I think it will be regulated as per the bar regulation. If any such kind of offense has occurred. But if say suppose any private wrong has been done to him, nothing relation to the advocacy, then obviously all the options which is open to any citizen of this country will be open to him. He can go to the court, he can go to the police station. So which particular things like what particular offense he is talking about is important to know here. Should I elaborate further?
Thank you, ma'am. So the next question is, could you please explain through the example the examination, chief and re-examination?
So examples, look, examination, chief and re-examination only we get to listen to, okay, and we get to read to, but we do not do the examination. It is obviously the lawyers who does this. So what happens is that in examination in chief, say suppose there is certain fact, because in UP all the proceedings always is in Hindi, so other than in the High Court, so it's all the things which we have is in. So in Hindi, so there will be like दिनांक इतना को इन अभ्युपगण के द्वारा घर में घुसकर इन व्यक्तियों को मारा गया और इस तरह से इनके द्वारा यह आपराधिक कार्य किया गया है, ठीक है. So now to begin with examination in chief. So here the complainant will come to the court and the complainant will on oath give a statement कि दिनांक कितना को अभ्युपगण ये मेरे घर में आए और उन्होंने ऐसे ऐसे मारपीट. उसके बाद this is examination in chief. He is making the statement which is more or less always same because I get to only read, so I see that it is always same as that of the plaintiff. जो उन्होंने कंप्लेन अपना लिखवाया एकदम वही स्टेटमेंट हो जाता है उनका, क्योंकि वो उनका वही this is what he is bringing to the court. अब the very important role examination in chief. Examination in chief is अभियुक्त के वकील, ठीक है. The accused lawyer will come and he will cross it कि दिनांक इतना को क्या आप यहाँ पे नहीं थे, क्या आप स्कूल नहीं गए हुए थे, आप यहीं पे थे, आपके स्कूल अटेंडेंस से तो ये दिख रहा है कि आप स्कूल में थे, ठीक है. So that is cross. He is asking the questions. That is he is crossing him. That's cross examination. And then again he will is only given in the case where the advocate of the complainant will feel कि हमारा means like I need to again make this point more clear, so I need to again question. So he will again come and he will again put the question to the witness कि दिनांक कितना को आप स्कूल तो गए थे परंतु तबियत खराब होने की वजह से आप यहाँ मतलब you cannot ask the leading questions, but obviously दिनांक कितना को आप यहाँ गए थे but तबियत पर आप वापस इतने बजे तक जिस समय घटना हुई थी आप घर में थे, इस बारे में बताइए. तो that will be, so this is basically examination chief, cross and re-examination. Okay.
Thank you, ma'am, for your explanation. So the next question is, if any police officer not register an FIR, can a person directly register his or her complaint to the judge?
Yes, that option is always open. No? If the police officer is refusing to register an FIR, that is what happens. That is the maximum application we get in the court. That is 156 clause 3. That's the application where every second person wants an investigation to be conducted, wants an FIR to be registered, and for one or the other reason the police is not is not is not filing the FIR. So obviously there's 156 clause 3 where you can seek the permission of the court. If you go through 156 clause 3 here, you see that it's it's not that in the complaint there is again another provision. In the complaint, the magistrate is having the power to order for investigation of a particular fact. So that is not what we are talking about. We are talking about that there can be an application under 156 clause 3 and the magistrate will order the police station to register the FIR and to make the investigation and to file the charge sheet. So obviously he has that power open. Both the things are there. And then again, obviously, if he thinks he can himself prove the case, he can directly file a complaint. Or if the magistrate feels that no need of registration of FIR no need of investigation is required, the magistrate may convert that may order under application of 156(3) to file a complaint to register a complaint, and then case परिवार की तरह चलेगा like a complaint. The case will move on.
Nice explain, ma'am. Nice explain. So the next question is, what do you mean by question of sentence?
Sorry?
Ma'am, what do you mean by question of sentence?
Question of sentence? Quantum of... I'm not getting... When did I say question of sentence? Like, in which parlance are you talking about? Question of sentence, one thing which I told about is like sentence, like quantum of the punishment, which I am saying. So when the trial is conducted, and there are so many trial proceedings which is given in the CRPC. So which particular trial will be done in your particular case? How are you going to get to know that? So that will be decided by the quantum of punishment. Is it a summon trial case? Is it a warrant trial case? Is it a case which is a summary trial case? So that will be decided through the quantum of the punishment. That is, which one section is involved. Say suppose there is section 376. So obviously section 376 is a session trial case. So the court of session trial, the session trial process will be followed for that particular case. Say suppose it's just 323, only 323. So a summon case, right? So this way we will decide as to which particular trial will be for which particular case. The quantum of punishment, like a person will be accused of many sections, not only one, 323, 504, 506, 325. So 325. So we see that it's a magistrate tribal case, it's a warrant trial case. So it will be, and if there is a state case, if a charge sheet has been filed, then the proceeding of the trial of a warrant case instituted on police report will be followed. So that is the idea of telling you about the quantum of punishment. Okay. Any other?
Yeah, yes, ma'am.
Any other questions?
Yes, ma'am.
More questions.
What is the difference between charge sheet and summon?
Charge sheet and summon. Summon is a very different thing and charge sheet is a very different thing. So there is a huge difference. They are from two different worlds. Charge sheet is something which is, charge sheet is under section 173. Okay. Charge sheet is something where after the police has completed an investigation, then he will submit charge sheet to the court. When we get the charge sheet, it's all it's in a laminated paper. The first, in the above section, all these sections are mentioned, which the police officer thinks that the accused is liable for. Then the small content of what all steps they have taken as total investigation they have done, and finally the conclusion where the last statement is अभियुक्त 1, 2 व 3 के विरुद्ध अपराध अंतर्गत धारा 323, 504, 506 प्रमाणित होता है, अतः उन्हें समन करने की कृपा करें. Summon is, you are summoning, the court is calling someone before the court, before itself. So there is summon. When you read section 204, you will see that it's not only summon, because everyone does not appear before the court when we send the summon. So then then we have the power to issue the warrant. Then again, warrant is a bailable warrant. First we issue PW, bailable warrant. We ask the accused, police will go with the bailable warrant then he will file he will, like, whatever amount of bail he has to put, he will give the bail, and then he will say that I will be present on this day in the court. And again, say suppose he does not appear, then we have the power to issue NBW, non-bailable warrant. Then the police will arrest him and will bring him before the court. And that's the reason why people like obey the court. If we will not have these powers, say suppose even in the case of NBW, the police is not able to find where the accused is. Summon पे नहीं आया, NBW पे नहीं आया, NBW पे नहीं आया, we go to the extent of 82. प्रोक्लेमेशन चस्पा करना, बाहर दरवाजे पे चस्पा कर देते हैं कि इस मुकदमे में न्यायालय ने आपको दिनांक कितने को यहाँ तलब किया है इस अपराध में. सो वी डू दैट प्रोक्लेमेशन, न्यूज़पेपर में सर्कुलेट करवाया जा सकता है. Even in that case, if they do not appear, then finally we go for attachment of the property, section 83. So it's like if there are high profile cases, it's very common that we have to go for section 82 and section 83 many times. So that is after the filing of the charge sheet, when the attendance of the accused is required in the court. Accused when will appear, then we will initiate, then the rest of the function will initiate, the trial will proceed. If the accused is not there, then how the punishment will be or how the justice will be done. So that is the way of producing the accused before the court. Okay. Yes?
What is the evidentiary value of extrajudicial confession?
Evidentiary value of extrajudicial confession. Look, when there is an extrajudicial confession made, so the it can always be used for the corroboration purpose. If extrajudicial confession is made solely on the ground of extrajudicial confession, it is very rare that someone is held to be someone is convicted. However, in certain cases, it has been, it's like extrajudicial confession. In certain cases, it's not like extrajudicial confession like death, like die declaration. So on that ground, someone has to know, but that is not a confession. So in extrajudicial confession, I don't think people are generally convicted. It's very weak evidence. Extrajudicial confession, if we take, then it never appeared before me, but if there's a judicial confession, it's a clear-cut case of confession. Extrajudicial confession, only if all the circumstantial evidences are proved, it's properly corroborated, then it can be used. Otherwise, it won't be used by the court for the purpose of conviction. No, acquittal will be easier in that case. If properly corroborated, then may be used.
So, ma'am, the next question.
Yeah, sure.
Which person can be kept in police custody without a warrant?
Without a warrant? Look, police custody, like I told you, there is again a police custody. Like, it's not necessary when there is a warrant, a person will be put into police custody. He will, in certain cases. But under section 167, there is a provision where we put the person into the police custody, right? So obviously, police custody is used many times by the court. But warrant, if it's NPW, very rarely we said, like for 1 day or 2 days we may, but we don't normally. No, not during pandemic. During Corona time, we are not doing this. We're not sending to police custody just in the case of warrant. If we can. If it's NPW, it's for a long time pending. So then obviously we will. If it's a very long NPW issued for a year or more than a year, an accused is not appearing, and if he appears, then it's important if he appears to send them to the police custody. We send them for the to the custody.
Thank you so much, ma'am. So, ma'am, which is more effective, is an offline FIR or an online FIR?
There's nothing like effectiveness of offline FIR or online FIR. It's FIR, and the procedure and the same procedure is expected to commence after the filing of the FIR, whether it be online or offline.
Thank you so much, ma'am, for increasing our knowledge and giving such valuable answers. Over to you, Sumit Bhaiya.
Okay, so there is also the career aspect was again one of the topic which I was expected to deal with. So you may ask me the question regarding the career aspect. Like, what kind of queries do you have about it? So in career aspect, what am I expected to tell you? Like, are you interested in judicial services? Or are you interested in doing the advocacy? Or what is it that I should be telling about? Like, if you are interested in judiciary, you know the kind of the study which you are doing. This is exactly this is the syllabus. This is what you have to study, and you have to clear the exam. That is it. So if there is any question regarding it, like I was in the recruitment committee. I have done many internship, and I was also in the law firm for a short span of time. I worked in the law firm. So if anyone is interested in the commercial, in the corporate world, wants to go to wants to join a law firm. So in that case, it is really advisable that you please keep a check on your CGPA, the marks, because they go for the marks, and you send lots of emails to all the recruitment cell of all the law firms. That's the only way how you are going to get the internships and then finally end up getting the placement offer. So you keep on sending the mails, and after sending the mails, now you can go to all the law firms website. You can find the recruitment committee cell. You can find the email ID. You can mail them up and keep a check, follow that particular thing. It's a little tedious process, but that is how you end up getting, how you end up in a good law firm. So if you do internship once or twice in that law firm, and if they're impressed by your work, then obviously you will get the placement offer there. So this is one way. Again, the another thing is that you may go to the High Court and the Supreme Court and work under some efficient advocates who are interested in telling you, who are interested in enlightening you with the work culture over there. So that will again be very advisable. Always use your time for internship. It's very important for a law student. Uh, if not more, then equally we learn in internship as much as we learn in the classroom. So internship is very important. Then again, you can also do internship under judges. That is again one way. Like if you are interning under a judge, then I think you get to listen to both the sides. So you are not interning under one particular advocate, rather you are introduced to lots of advocates and the way how they are functioning, how they are making the argument, how they are preparing their case. So that is again one thing which a law student can do. Then again, for a law student, do writes of articles, write article and send it to all the publications. Just hope for it being published. Okay, you can uh, send it to means like whichever law firm, whichever book publication house you want. And apart from that, like articles, internships, MOOC, lots of MOOC is important because your CV will enhance. You do the wide variety of activities. It should not be very narrow. Like you studied this, you achieved this with marks. That is like, so what extra activity have you done, or how much you have been exposed to the outside world. So go through this. Then again, there is for a law student, there's again this very new concept which have arisen. You can on the social media, lots of activities you can upload your books. You can do so many things. There are lots of glass ceilings which are waiting to be broken, and everything is like you have to go imaginative. Like recently, I've started this. I along with my husband, we are like trying to make this law freaker website for the purpose to help these students, because when we were there, when we were as a student, we was in the classes, we were not provided with the very idea which we needed. So here again, so you can also do these small little activities, and there are lots of options open. Be imaginative, be innovative, and be hyperactive at this stage. Because the fourth and fifth year will be like ultimate years. Do as much things, as much activities. Student life will not come back to you. So use it to the fullest, to the maximum. I would advise write articles, write very good articles, get it published. Like I one time wrote an article and I went to Times of India office its publication. So if you do not get the website, if you do not know the link where you have to send it to, do this. I wrote an article, I sent it to Taxman and it got published. You never know when it will happen, when it will not. There's Manu Patra, there's so many things like, so be active and this will bring Laurel and you have such a good infrastructure, such a good facility available. The university is providing you with such enhanced library and all the facilities are there, so use it to the maximum. So right now it must be, since you all are at your home, so it will even be more beneficial for you. Use your time for all the activities which you can. And there is also one which I did was legal researcher to the Supreme Court judge, or the legal researcher to the High Court judge. So those kind of things also is something which you can do. It will help you a lot. So these are the things which and then obviously if someone is interested in LLM, and after doing your LLM, you can clear the NET, you can become a professor. A very excellent career option is there. So all these options are open. Do think, but it's not confined to this. You may think like there are so many venues open that even a person from that particular field cannot even imagine what all he can. So when I said, I get so many ideas that I can do this, but now there is paucity of time. But since you all are at your school, still students, so you all can do so many things. And do as much as you can so that you do not end up regretting. That is the most important thing. Feel happy that I did this. Enhance your CV, that's the important. Mail at least 50 law forms in a week and then do the follow-up for next 3 weeks. See, something will come up. Something will happen. Internship will come up. The publication will be made. For the publication, you need to sit and write. And the quality should be of good enough for it to get published. So you have to do the research. So all these functions are training you to be a good law researcher, which will be ultimately required if you be an advocate, if you be a judge, if you join anything. So that's the thing which I think every law student is required to do. It's not just sit and read, it's to do all other activities which is around. Then you will enjoy the law the most. So this is with regard to the career aspect. Is there anything that I should be addressing more?
Takir, here's a question from Diba Faryal. Please ask them. Takir? Okay, ma'am, a question from Diba Faryal. What is the evidentiary value of extrajudicial confession?
The evidentiary value of extrajudicial confession. Look, the extrajudicial confession in itself is not considered to be sufficient to convict. Okay, but can always be used for corroboration. If it's properly corroborated, if there is other circumstantial evidences proving it, then it can be used. Okay, so this is basically extrajudicial confession is not of that great importance to the court for the purpose of conviction, but is certainly important if it is also corroborated with certain other evidences. Then obviously the court will go on to convict. Now, we have to, like always, until proven guilty, the accused is considered to be not guilty. So for that particular thing, there is a soft corner of the law for the accused that he should be proved beyond reasonable doubt. He should be proved that he is guilty. So extrajudicial confession will not in itself be sufficient for the purpose of conviction if it is not corroborated. If corroborated, then it will be. If it's clear.
So, ma'am, there is another question by Akash Sen. What are the conditions of dismissal of complaint by court?
Conditions for dismissal of complaint, if court thinks that no case is being made out, like there are many times where we get there is no offence. It's not a cognizable offence. It's not a non-cognizable offence. A student comes to the court and files a case against the teacher. We do not know what kind of offence is there. So on prima facie, we see that there is no offence being made out here. We wait, we take down the section 200 statement, we take down section 202 statement, and we find that nothing is being made out, so we dismiss it. The importance is not what the lawyer has drafted in your complaint. That is not important. What is important is that when that particular complainant comes before the court and he makes the statement, then we get to know. Like, I write the statement, I look into him, and the statement is just what he is stating. He just starts to state something else. This many times happen. Many times they come up with a cooked up story. So if you start actively participating into it, the story will all fall. Like, he was like, ये था वो था, इतने बुरे से मारा, ये किया. And after that, it's all that the teacher shouted at him during the assembly time, and he got very angry about it, and therefore he came and he filed it. So if a teacher is shouting during the assembly, there is no consistency. Why will I entertain that case? There's nothing he can prove. He does not bring a doctor. He filed koi slip, parcha medical ka. There is no doctor to prove it. He is having no other witness. I will dismiss the case. So dismissal of a complaint, like it's not like point 1, 2, 3, like on this ground it will be dismissed, on this ground it will be dismissed. If overall the satisfaction to the judicial magistrate is not there, then he will dismiss the complaint. That is it.
Thank you, ma'am, for giving your valuable insights. I think that everyone must have learned a lot from this and will prove to be helpful for doing something in future. I would like to thank everyone, and especially lovely ma'am. Yes, ma'am.